Hello everyone. First of all, we want to say that we're back from the break. It's Game Gathering 2023, first day, online date, and today with Alyona Furda, Oleksiy Stolyarenko, and Radzym Wojcik, we're going to talk a little bit about some legal questions. So if you got some company, some business you're running, and you want to do some business with international partners, obviously it's I would say super complicated. And now we got, I hope, not just useful but interesting election about how to do international business. So, guys, wish you luck.
Uh, Hello, everyone. Thanks for your attention on this topic. We will cover some of the things. We, of course, would not be able to cover everything, but we will cover some of the things that you should remember. First, dealing in Ukraine, in being involved in a game development business, aiming to sell your company or get funding, and also some things in relation to Poland that also applicable in general. So I'm very happy to start first from our small team, Baker McKenzie team, containing Alyona Furda from our Kyiv office and Radzym from our Polish office. So here are some general slides that hopefully organizers will provide them to you so you can read them later with some credential and background information on us. And let's start from some basic questions which we receive all the time from the companies that are going to engage people in Ukraine in game development, or they would, for example, want to sell their company, get funding and something like that, and they do due diligence or pre-sale due diligence. So some of the key issues that are coming up and very important for the industry, of course, contractual side of the dealing, in particular the IP rights ownership. So this is a top question we received. So who owns the IP rights that your developer developed for you? And historically, that has been a complicated question in Ukraine. I know particular the guy who invented the Ukrainian rule, which was that the IP rights are owned jointly both by the developer and by the company, unless something else is mentioned in the agreement. So the idea of this rule was that to make companies and the developers aware of IP rights and promote trade in IP rights. So the people, developers and companies would consciously organize and sell and they would try to get additional, to give additional remuneration, and developers would try to get additional remuneration for these IP rights. So, and that has created a lot of complications for lawyers, for us, because when there is no adequate provision in the agreement, you sort of end up with this joint ownership. So the situation has been gradually changed in different areas, and right now there is different regimes in the different areas. For example, in copyright, there is a default rule that the IP is owned by the company that has hired an employee or contractor, the customer of the contractor. In other spheres, there is still this joint ownership rule. What you need to remember is that you need to really have a good contract where everything is written. So then all of this headache goes away. So default rule right now is gradually changing. So, but still there are lots of historical issues. If you want to check out your agreements with the developers, look at this: who owns the IP rights? So what is default rule and what's written in your agreement? Also, there is an issue of the scope of the rights owned. So traditionally, the rights are owned within the scope of the employment agreement or within the scope of the contractor agreement. So you need to write what works have been ordered for the employee or contractor to be done in order to acquire IP rights on them. For example, if you have a software tester who came up with some amazing design or came up with some picture, and he is not legally required to develop any design, or he is just for the testing purposes hired. So then you have an issue of the person who has developed and can argue that this design has been developed by him independently without direct order of the customer or of employer. So that could be an issue for the future ownership of this design. So that's around the scope. So in your agreement with the developer or contractor, you need to have the scope clarified. So you own all of the rights. Moment, that's a very interesting part. So also when somebody is developing for you, from what moment you're getting the rights in the IP they developed. So right now the law, in particular in relation to copyrights, and I suggest in relation to all IP rights to set it out contractually, mentioned that this moment should be the moment of creation. So because sometimes, for example, you can say that the IP rights are transferred from the moment of payment for the development, for the works and services, and then you have this gap when the person owned these rights and they could have assigned them to somebody else and so on and so forth. So why do you need that? So check your agreements in relation to this issue as well. And remuneration. So every employer contractor is entitled for additional remuneration in relation to created IP rights. So right now, and there was a discussion for a long time, so whether this remuneration could be included into the salary or payment based on the contract, or it should be paid separately. So right now we see that the legislator is putting this into the payment. So it's allowed to combine both payments, the salary, for example, and payment for IP rights created. The same goes for the contracts for development. So you can combine all remuneration altogether. So pay attention to these issues. Act of acceptance. Who works in Ukraine for a long time, they know that there is a strange document in Ukraine called Act of Acceptance. So it's still mandatory in Ukraine. So when you finish your contract or a part of your contract, you need to sign with the developer that he had delivered some works and you have accepted some works. However, this act of acceptance is not necessary for the foreign customers or foreign employers. So, for example, in our standard form, contractors form, we don't have act of acceptance because it's a redundant form which does not need to be signed in relation to the foreign contracts. Where the foreign party is the contractor or employer. Also, there is a very often question which we have whether we can have this agreement with a developer or contractor being based on foreign laws, and whether the jurisdiction could be outsourced to foreign courts. So right now, we had also developments over the last couple of years. The response to both of these questions is yes. So you can both indicate that the agreement with the Ukrainian national which has an international element, like foreign company is the customer or contractor. It could be governed by foreign laws, and it could be outsourced to foreign courts to decide. There are amendments to the procedural rules that say if the foreign court accepted the case, so the Ukrainian court would suspend the case if it would be filed in Ukraine. Another good question which is coming up, especially in advance of technology of signing everything online, whether we can sign agreement with Ukrainian developers online or electronically, or should we sign this agreement on paper? Well, that depends. And the answer is that we recommend to still sign it wet ink agreement because if you want to go to the court, if you want to for the developer to file taxes, tax returns, or something like that, most likely there would be needed a paper form of the agreement. There are different experiments. In Ukraine, we already have electronic qualified signatures. So between the Ukrainian nationals and Ukrainian companies and Ukrainian developers, you can sign these agreements electronically, and that would be acceptable for the tax purposes, reporting purposes, and so on and so forth. However, when we're talking about foreign qualified or foreign simple signatures for the purposes of agreements, that is still a complicated issue. And the last thing that I wanted to raise is the data privacy. It's a big thing in many jurisdictions worldwide. And whether you should be concerned about data privacy regulations in Ukraine. So for now, the short answer would be not so much, because we have a little bit outdated regulation and law, and also the amount of fines in Ukraine are quite, let's say, moderate in comparison with GDPR and other countries. So the fine for non-compliance of the law would be around $100, so which is laughable in relation to the GDPR fines. However, it's going to change, I think, pretty soon. So Ukraine is aspiring to join the European Union, and we have already several draft laws aiming to implement GDPR. So there would be not GDPR size fines there, but still considerable fines for non-compliance. So check out the current status of the data privacy regulations and monitor developments, because it's likely that the data privacy rules would be updated in Ukraine soon. I'm passing, that's basically all what I wanted to say, 5 key things to remember, and I am passing the screen, the show to my colleague Alyona Furda, and she would raise 5 things which she would want you to avoid during doing business in Ukraine and internationally.
Hi, everyone. Really nice to speak to you today. And also, Radzym, please feel free to chip in, because I know that you have quite an extensive experience dealing with M&A transactions. So basically, what I want to start with is that you can work with international companies, you can work with international, let's say, counterparties, but at some point, I think each of you will think about either selling your company or probably to the fact that you need to attract investments. You need to attract investments for making your team bigger, for finding capital to, I don't know, to make a new project, for differentiating your business for many different reasons. And at some point, you will think about it. And then you will think who should be this investor or buyer of the company. And most people will say now that they want these companies to be international companies. Because when you sell your company, and basically because when you become not co-founder, but the shareholder of this company together with international investor, then you work together on the same goal. And then sometimes, and especially nowadays, this international investor, they do not only bring cash to your business, but they can also bring knowledge, expertise, publicity, and many actually good things, especially because there are such investors, like Tencent. Everyone knows them, and I would say that everyone wants to work with them. That's why you need to protect and, I would say, prepare your company for such big investments. And that's why I decided to speak about 5 mistakes while preparing your company for big business, basically from M&A perspective, when you want either to sell 100% of your company or you want to attract investor, which will buy, 10%, 20, 15% of the company, which will bring cash to the business. And this cash will give you opportunity to grow and become bigger and become better and become prosperous. So first mistake you should think about, it's complex shareholding structure or corporate structure. Basically, it's not a problem if you have the complex shareholding structure. What is the problem for you is that you need to explain the structure to your investor. Why is that? Because they will understand that they either need to spend money on restructuring of the business after they buy it, or indirectly they will spend money on it if they invest in the company. So if you have, let's say, a Cyprus company in your shareholding structure, and you can explain that you have this company because of IP box regime, because of other tax purposes, then it's perfectly fine. But if you have, 5 different companies in different countries, in France, in England, and then you say to the investor that you have such a complex structure because you used to have it, because you decided not to change it, because, you have employees there and you think it's good for them to go to the office, and that's why you don't want to change it, then probably this is the bad approach, and probably you will be asked by the investor either to change this corporate structure before you sell the company, or probably they will be okay to change it afterwards. But the purchase price you will receive will be less, because this purchase price will reflect. Sorry, Radzym, go on, please.
I just wanted to add that this corporate structure is also important for one additional reason, because today it would be very important for especially the international investor to understand what parties are involved in your business as a shareholders. And they really need to be sure and feel comfortable that those people are not sanctioned. And as you probably know, it is possible historically that in some of the, in general, Ukrainian tech businesses maybe involve people that are now sanctioned. Right? The people I know told me that they really wanted to invest in several startups, in tech startups in Ukraine, and then, like 2 of them, it appeared that Roman Abramovich was one of the shareholders, and it was a big problem for them naturally to invest in those startups. So it is really important to understand that this could be a big issue. It is really important to do diligence this before and to find a solution how to overcome this situation before you approach the investors, so you can approach the investors with a clean card and with no history that could jeopardize your efforts to fundraise.
Totally agree with you, and it's also something you should think about from the very beginning, because there are some investor that let's say doesn't work with investors from other countries, from particular country. That's why you always need to think about this, about the portfolio of your investors, let's say like this. Another thing I would recommend you to think about, and not to make this mistake, is unstable talent team. So I remember my first M&A project where with factories, pharma companies, like huge business, and then you see it and you can feel it. The problem with game developing studios is with IT companies is that sometimes you cannot touch it. You cannot touch this asset. But at the end of the day, you need to understand that the main asset. There are several assets of gaming companies, but one of the main assets are people. Basically, these are the main key talent team that are working on your product, and this team should be on the same page with you. They need to either know about the investment or to support it. And basically, the investor needs to be sure that these people will be on board. They will continue working with you. What is the problem is that investor can buy the company because of people, because of these talented guys. But the next day, these people can leave the company and then can start another company. That's why during the due diligence, the investor will make sure that you have these people on board. Then everything is okay in their contract. For example, what they will look at is that if you have in a contract the termination notice, which is like, say, 10 days, this is something probably will not be good for you, because in 10 days, you will not be able to find the replacement for that key guy. That's why the investors may ask you to amend this contract, to make it before closing, or again, to reduce the purchase price, because they want to make sure that these people will be in the company. And I do not say that it's slavery. No, but they need to make sure that they will be within the company, or that you will be able to find the replacement for them in the short period of time. And this resignation will not affect the business. That's why it's vital to take it into consideration and to understand that your people are basically your assets. And this is something the investor will due deal and will look at before buying your company or before the investment. The second mistake, this is basically the most common mistake we usually see. This is deficiency with IP title, IP transfer provisions. This is Do you hear me?
Yeah, you are again with us. Alyona?
Alyona, please go ahead. We do hear you.
Okay, something with net. Anyway, let's go on. So yeah, this is the usual risk, because usual mistake, and Oleksiy already started saying about this. What's the problem is that, again, IP title and transfer provisions, that's the main assets of the company. That's why you need to make sure that everything is clean with it. That's why you need to make sure. This may be the problem at different levels. The first problem Oleksiy mentioned about is whether the IP rights are transferred from the employee to the company. The second one I usually see is basically when the IP rights are within different companies. And then you may sell not all of these companies. That's why it's vital to have this IP at one company, to make sure you know where is it, and to make sure you use this company afterwards for the transfer, for working with other counterparties in terms of IP. But that's really vital to understand that you need to make this the structure clear. Why it is so? Because if it's not clear, the investor will ask you to fix this before closing. And it means basically that the transaction will not be in 1 month, surely, because this is something that triggers timing, additional timing for fixing that. That's why it's good to look at it, to understand whether you have any problems with it, and to fix it at the very beginning, because there are some IP-related problems that cannot be fixed afterwards. And that's why usually when you have such problems and when you have transaction documents, you see this risk reflected in the transaction documents. For example, it can be indemnities from indemnities given by the founders of the company to the investor. Because, for example, some of their IP rights are with employees that left the company many years ago. And then the investor don't want to take the risk of these employees coming to him the next day saying that, okay, I have this IP rights, you breach them, and that's damages, and I want you to cover them. That's why, in order to cover this risk, the investors may ask for indemnities, and this is something that should be given by the sellers, by the founders of the company. So obviously, if you don't want to go with it, you need to make sure you have the structure clean, you don't have any problems with it, and it's quite easy to explain to the investor. The next mistake.
Yeah, Alyona, I will jump in on the.
Sure.
Also, I wanted to add, I think that's what we have seen with Alyona working on these deals, is that it's also important to see that if you want to sell a company, or at least you have an idea that at some point it would be sold, then it's better to keep all the trademarks, all industrial rights on the company, because if you have on other company, or as Alyona mentioned, in different companies, so then even the procedure to transfer these trademarks within the group, from transfer trademarks from one company to another company, it would take at least 3 months to register these amendments through the Ukrainian Trademark Office. So, and that's without word, it is like 3 months. It could be longer. So you may end being stuck with this condition precedent. So you need to concentrate all of your IP rights within one company in order to sell it, and then you'll spend significant time doing so. While the investor or buyer might not want to wait that much time in very challenging and changing conditions. So keep in mind, if you want to sell the company, keep all the IP rights. There's some IP rights might be longer to transfer than others.
Thank you, Oleksiy. Next mistake I would like to start with is hiding historical risks. This is something we may be used to, but basically, please do not hide any risk you have, any problems you have. Just come with a clean hands. Why it is so? Because of several reasons. First of all, investors will find. They will definitely find, because I don't know, in all transactions we work for big investors, they do due diligence, and due diligence are done by people like us who knows the market, who knows the risk, who know the mistakes, and these mistakes are mainly the same with all companies. That's why these historical risks will be found during the due diligence process. That's why it's vital not to hide them. Secondly, if we are saying about investments, you will be working with this investment side by side, and that's why you don't want to breach this trust from the very beginning. That's why, and also, by the way, most transaction documents in this sphere are governed by either by English law or by the US law, or I don't know, we see also Hong Kong law. The main concept of buying the company subject to this jurisdiction is that you buy the company as it is, which means that if you disclose the risks you have and the investor accepts this risk, he buys the company as it is, and it's his choice to invest. It's his choice to give you the price for this company. That's why if you disclose these problems and the investor decides to go with a transaction, that's not your liability from this point. That's why it's good to always think about these mistakes. It's always good about being compliant, but if something happened, just try to fix it. If you cannot fix it, then just be be open about it, because again, there may be different effects of hiding such things during the preparation for investment. And it's better always to think with your investor how to fix this and try to fix it instead of just hiding these risks. The last point I would like to speak about is reluctance to cooperate and to change. Again, this is something that will not be triggered if you sell your company 100%. But definitely, this is the case when a big investor comes to you and buy 10, 15, 20% of the company. So you attract investment in this way. Usually, these companies want you to take some undertakings. For example, not to work with competitors, or probably to work with some publishers, or probably they want you to follow their internal policy. That it's something quite understandable from investor side. And basically, our advice to you is to be cooperative and to again to work together for the same goal, to make your company a big one. And it's better not to be reluctant. It's better to stay on the same table, to discuss things and try to find the best solution for that. Because again, for founders, for shareholders, you may think that this is your only company, but for investors, it's not the case. They invest in 10, 15 other companies each year. And probably they try not only to find the good asset, but they also want to find the friendly, cooperative founders, shareholders that will be willing to build this company with investors together. And that's why it's vital to be cooperative from the very beginning of the transaction and to work towards one goal. So I would say that, as one said, intelligent people learn from mistakes other people make. That's why please start to think about these 5 big, from my point, the biggest mistakes usually IT companies have in Ukraine. Try to probably think about them from the very beginning, try to fix them. If not, try to find the good counsel that will help you to prepare your company for the investment, because investors will anyway find this company, there will be a third party that will make the due diligence of your company. But it's also good to have the due diligence, internal due diligence of your company before the investments, because in this way you will be prepared for these risks. You will know that, okay, I have this and this issues and I need to fix them, and you will fix them on your own or with your counsel. And if not, then you will work on how to present it to the investors and how to fix this together. Of course, your internal team can also help you with that, but sometimes it's good to have a third party to look at it and to say, this is okay, this is something accepted by the industry, by the market, and this is not okay, and it's better to do it in this and this way, and we can quickly fix it together before the investor approach you. Thank you very much. I will now pass my words to Radzym.
So thank you. I wanted to start with saying that we wanted this panel to be interactive and to be helpful and to meet also your needs. So if anyone who's with us now has any question and wants to ask about anything, please do, and we're open to answer any of your questions and to address any of your concerns that you may have. And please, don't wait and do this any moment, and we can pause with other slides and answer to your questions. I'm going to talk about the important legal topics that you should be aware of or you should be concerned about while designing and developing your businesses. And I would like to start with saying that in general, digital entertainment is a global kind of business. even if you develop it in Ukraine, in Poland, anywhere, you can compete with the biggest game dev studios. And actually, what is important is your idea. And I think that with the rise of the generative AI tools, it will be even easier to develop your ideas, only if they are interesting, moving other people into something big. And if you have great ideas, if you can develop them into something solid, something that you can share with the audience, then most probably your game dev business will be global, and you will have many interactions with international investors, with international regulations, with international offices of your company. So you need to think about your business as a global business, and that is also a basis for my choice of the legal words that I want to present to you. Um, Maybe starting with regulations, because one may think that technology or game dev is something like a freelance, but this is not the case. And entering the different markets, you need to be wary of the regulations that may appear in those jurisdictions. Some of those regulations were already mentioned by Alyona and Oleksiy, like GDPR, that is a standard thing in the European Union, and I understand in Ukraine you are developing your set of rules that will be very similar to this one. You need to be aware of the anti-money laundering and about sanctions. This is also what we already mentioned about foreign direct investments rules being a rules limiting possibility of an investment in the company by some investors from some countries. So and sometimes there will be a difficult choice for you whether you want to change your way of operating your business to comply with regulations that may be challenging or difficult in one jurisdiction. And there are some entrepreneurs, some companies that decide to not operate in a jurisdiction where it is too difficult, or if it would be too challenging, or if it would require them to change their core of operation, while it still is okay for all the other jurisdictions. Then I would like to mention tax incentives, because today the ideas can appear anywhere, but then entrepreneurs may decide to develop them someplace else, and the countries try to compete against each other and to attract entrepreneurs to develop their ideas in the jurisdictions that are developing to be attractive for entrepreneurs. So this is something that you can also explore and try to find out for yourself whether it works or not. I think that the important thing here is that you must remember that if you decide to relocate to some other jurisdiction, you really need to have a substance there. So this is not so easy from the tax perspective to just open an office and don't have developers, your presence, and so on, and use the opportunities, incentives that are present there. ESOP is something that I guess also Alyona has mentioned before. This is one of the crucial tools of incentivizing the team. What I really like about tech businesses is that the success of those businesses is really shared by a wider group of people than only like the CEO or the close management. And today, to retain the team, it is very, very important for you to give the wider team a right skin in the game, right? To incentivize them to really contribute to the success of the game, and most popular tools how to incentivize the wider team is ESOP, or employee stock option plan. So in other words, it's some kind of a bonus, some kind of a part of the shares in the company or in the profits. So it's a tool allowing the wider team to participate from the business perspective, or from the cash perspective, in a success of your game. And somehow earnout is an equivalent in the transactional world. So when at some point you decide to exit the studios that maybe you are now developing, in today's transactions, it's more and more common to structure the cash out from or the price for the shares in the studios on the basis of the earnout. Why? Because very often when you buy game dev studios, the buyer acquires some work in progress, and there could be a difference in the opinions of the buyer and the seller about the prospects of those work. And of course, the buyer will try to undermine or to put in doubt the stellar prospects that would be presented by the sellers. So to breach those two ways of thinking, it comes the earnout. So this is a deferred part of the price that is conditional upon certain situations. For example, certain number of the games that will be sold, or certain financial result of the company. And especially if you are now planning to sell your studio, this is something that you really should be aware of, because this is a very, very standard mechanism in the present market. And finally, exclusivity, that may have different forms in the game dev world, because this may be exclusivity in negotiations of various different things, starting from negotiations with the investor. And one investor may come to you and say, okay, we want to present you the term sheet and the financial terms, but we expect you to focus on the negotiations only with us for some time. But then, especially with the industry investors, so if you decide to be financed and supported by the investor that is a publisher at the same time, they may request that your future game, that they will have some kind of a special treatment in case of a publishing deal, or in case of you entering to certain markets, and then they may require that they will be your exclusive partner. So here you should also be aware, or you should be considerate about it, because sometimes this might not be the best for your business if you too early agree that your investor will be also your publisher in the future. Because naturally, if there is a competition and if various parties compete for a publishing rights to your game, it allows you to have the better terms. So now it's the time for your questions.
Thank you, guys. Very informative presentation, I would say. A lot of useful information, and I would say I have one question for myself. So let's imagine the situation, I think, could be like pretty common. I would say I'm like indie developer, or like me and my friends, like small group of indie developers, we preparing some game, and after some time we realized that it could be like something bigger than we expected, and we decided to find some partners, like investors, publishers, that matter. But unfortunately, we're very bad in networking, like usual, and we don't have any expertise. So we couldn't maybe afford ourselves some big like well-known partners, and there are a lot of, let's say this way, like no names. So maybe there are some like red flags that we should like put our attention on, and to understand that this potential partner is not good like for our first run. Is it something like the beginners should put attention on?
So I think that beware of the people that promise to match. This is the first thing, and try to understand the contracts they bring to you, because sometimes there are people that promise you like millions of dollars, but at the same time, the contract says that whatever funding you get or from whatever partner in the future, they want to have a cut. So they may do nothing eventually, but still request some fee from you. So I would say that this is the one thing, and the other thing, from my perspective, what is great about the game dev scene, all in all, it's not a big world, right? So this is, and it costs nothing, and it should not be very difficult to do a to ask the people, like for example, check with LinkedIn whether you have some friends in common or contacts in common with this person approaching you, and if so, try to ask the friends in common about this person, about his or her experience. And also, I think that if you don't have anyone in common, that might be some kind of a red flag, because as I said, this is not a big world.
I would also add that definitely I agree too that it's not a big world and everyone knows each other. So most investors are well known. So if we're saying about well-known investors, you will not be their first investment for sure. So you can speak with people, you can speak with community, you can find the company they already invested in, and then you can discuss how is it going now. Also, why I tell to look at the contract from another perspective is that if it's investment, if it's a, let's say, 10%, then probably you would don't want this investor to interfere with your day-to-day activity, and probably while you want to cooperate and while you will be okay to comply with their undertakings, there are something you want to be controlled as someone who will be doing day-to-day management and who will be responsible for this company. That's also something you need to look at. Usually this is reflected in the subscription agreement, in the shareholder agreement, or in the charter of the company. And also, what Radzym also already mentioned in the very beginning, now nowadays the sanctions list is becoming bigger with every day. So that's why probably you also need to keep an eye on this thing and make sure that your investor is not within the sanction list.
And I have also one additional tip. If you are an aspiring game studio and you are looking for an investor, you may try to reach to the people that have a wide network. And I think that lawyers like Oleksiy, Alyona, myself, we know many people from many game dev companies, and I never ignore emails from entrepreneurs that approach me and ask, look, maybe one of your clients, either financial investors or industry investors, could be interested in talking with us or in investing in our business. And that allows to use someone other's broad network.
Yeah, and this small bit from my side, the Alyona and Radzym, they're talking very high level, but what I can add, do have something in writing, because especially for indie developers, they have this handshake agreements with somebody. Okay, let's agree, this is a great idea. Everybody shook hands, and the months later, you don't have a clear idea who is doing what, who is responsible for what funding is coming from where, and so on and so forth. So do have start planning it. Not try make a legal document from the beginning. At least some understanding how your cooperation would work. And then you go, for example, to us to lawyers, and we would have something to start with, terms and conditions, term sheet, something like that. Then we can add. It's not that complicated to add, legal things and make it binding, and everybody would agree. But if you have already the structure and you understand how it works logistically, that's already a big step forward. So when you do this napkin agreement, handshake agreement, try, make some bullet points. This developer responsible for this partner is responsible for this. This is how much it would probably take, and so on and so forth. So if you take these small steps, then you can elaborate and always, talk to lawyers, and you will see that lawyers will be understanding what do you want if you give them this sort of at least starting details of how it would work.
Got it. Thank you. That's, I would say, pretty understandable algorithm for all like developers, like big and small. We got one more question from our audience. So first of all, our viewer want to say thank you all for very useful info. So thank you guys. And the question itself. So it's for everybody. From your feeling, how active? Pardon. How active? Oh, what's wrong with it? Like couldn't give me my question. How active the market of game investment publishing in Ukraine right now? Does quantity of deals you are seeing now could be competitive to pre-war status?
Oleksiy, will you start or want me to take it?
I would just start that we with the gaming companies in Ukraine, the most deals we have seen is that acquisition of Ukrainian or game studios, but it was not always a Ukrainian game studio. It was like sort of a network of companies. So they would usually acquisition would relate to a number of companies in different jurisdictions. So there were not that many acquisitions of purely Ukrainian companies. So it's hard to calculate the first thing. And the second is my perception is that, of course, the war affected the market. I'm not. I don't know exactly about the gaming market, but the general, even the general development market, there is a decreased activity because of people not understanding what is the continuity of work, whether the studios are relocating, what is their status, whether the people who are game developers, whether they would be drawn to the enlisted to the army, how all this DIA regime would work, and so on. So many questions that, of course, investors are taking close attention to these issues, and this affects their decisions whether to invest and consider Ukrainian studios or not. Alyona?
I would add from my perspective that obviously there are more acquisitions and more investments before the war. But also, this is probably not only because of war. This is because of several factors. First of all, we have a general downside in IT industry in the world. Secondly, it depends on the target company, because sometimes they are willing to find the target company to invest, but they just couldn't find it. Probably also the question is about the target company itself, because we had problem with electricity during winter, and of course, if these problems affect your company, that there is an issue. But some IT companies I know relocated to Warsaw, to Poland, right? Some of the companies prepared for winter. They have generators and they are totally independent, right? Again, this is sometimes something the investor will look at while evaluating whether they need to take this investment or not. And just to add one more advantage of why to invest now is, again, it's like with real estate, everyone is waiting when the price goes up. So I would say that it's, again, you can buy today, you can buy later, but the price will be different. And also it depends on many other factors. But I would say that now we see the investors from Ukraine spending cash because of the regulation and limitations of the National Bank in Ukraine on repatriation of dividends, which are currently forbidden. They want to spend this money in Ukraine. So if there may be also a good chance to find the investor, we've seen, let's say, other foreign companies that are looking for the way to invest, because they need to spend their cash. Otherwise, they will just lose at the end of the day. So again, this is an opportunity for gaming studios and for IT companies today.
Yeah, thank you.
So I just wanted to say that not being Ukrainian, I'm impressed with the resilience of the Ukrainian tech businesses. So I think I'm sure that there are great things ahead, and that the investors will appreciate it. I think that, as Alyona mentioned, now that the momentum for the tech investments in general, like globally, is slightly worse, and it's slightly more difficult. But this will change eventually.
Got it. Thank you very much. So we got, I think, like 1 or 2 minutes, but we got very small, very practical question for all of us, I think. So one of viewer asking, does an indie studio have to register as a legal entity before applying to investors?
Well, that's the structural questions, depending on the level of investment, I would say. So Alyona probably would add to that, but it depends how much and what type of investor do you want to bring. If you have some, basic partnership agreement, then you probably don't need to have a company to do that. But if you created something and already trying to, you have some revenue, or you have some substantial project going on, and so on and so forth, then probably then you need to register a company and already have some shareholder agreement with the investors, and so on and so forth. I also wanted to add a little bit to lighten the mood on the previous question, and in commenting the Radzym comment that the Ukrainians are so resilient. So if you invest in Ukraine now, you see that even like a zombie apocalypse, if it comes tomorrow, it would be not a big change for Ukrainian developers. They all have, everything they need to survive. They have water, they have emergency food supply, they have even, guns and armor to kill the zombies. So if everybody, whole world would be in crumbles, the zombie apocalypses, and Ukrainian developers would be like, oh, whatever, we have seen it all, no big deal. So that's on a humorous note. I'm passing to Alyona more to comment on the issue of shareholder agreement.
I would say that everything depends on the size of investment. Definitely, if you have a good international investor, that investor will want the target company to be established, right? Because this is a target of the investment, and you cannot write an agreement without the entity. So if you have a small investment, if you have, let's say, 5-10 guys working on the program, working on the product, on the game, then probably, and you have a small investment, then probably it will be okay. Because again, the investor wants his investments to be protected. And if you do not have the agreement, probably that investor will not have any protection. So that's why everything depends on investment.
I see. Okay, so usually how we imagine it, like in our gaming sphere, indie studio could be just one guy and his friend 2 people is already a lot, doing the like indie project during their free time, and they have usually some alpha build, like kind of playable, but still pretty far from the final product. And a lot of people, when they got in this exactly particular situation, they already start to think, should I like already, not just to make like legal entity, but like to choose a name and do some branding. And like it's not absolutely big, but just, first maybe 2 or 3 steps of doing the product, building the company, and understanding like, do I need it or maybe not? So still like on the first like very small steps of doing something, is it still very necessary to do all these Lego questions, or it's better to do it like a little bit later when you got at least like working product, I would say, like playable build of the video game?
I think Oleksiy can comment on compliance issues from his perspective. From my perspective, I would say that you should not start with spending money on. I'm a lawyer, so you should spend my money on lawyer. But to be honest, I think you should not start with spending money on things you may not need, right? So if you have the product, if you develop this product, but you're not sure about your idea and whether you will do it in half a year or not, or whether this product will be launched this summer or not, you should start to think about the product itself, right?
Yeah.
Probably you do not need even this investment. And at the end of the day, when you have this product and you believe in the prosperity of this product, then probably you need to think about whether I need this investment. Do I want to sell this product, and whether I need, or do I want to sell the company at all? And then again, you may do and you may prepare this corporate structure before going out, before start to find the investors, and you can fix it before the time. But again, look at compliance things, because if there are the only one making the product that's perfectly okay, I think, because there will be no claims from IP perspective. But if you have your neighbor, your brother, and some other guys, then probably you need to think about things Oleksiy mentioned from the very beginning, and to fix it from the very beginning. It's not so much legal work to do, basically, but it's good to have it under your radar.
Yeah, thank you very much, guys. So it was pretty clear, and I think a lot of our viewers now understand what they need to do or maybe not to do right now. So, Alyona, Oleksiy, Radzym, thank you very much again for your lecture. It was very interesting, very productive. So, thank you very much.
Thank you very much.
Thank you.